So welcome to the second day of the 2020 China-EU conference on IPR protection online and innovation, co-hosted by CAASA, who's the Anti-Counterfeiting and Anti-Infringement Alliance. CAASA is a non-governmental and non-profit organization focusing on intellectual property protection, anti-counterfeiting, and anti-piracy. Since 2015, CAASA has been committed to implementing the societal co-governance on IPR protection in cooperation with its members, which include international partners, internet platforms, brand owners, industrial associations, and academia. The second co-host is IPK China. IPK China is directed by the European Commission and implemented by the European Union Intellectual Property Office, or EU IPO. We aim to support and facilitate market access to international firms and innovators, focusing on concerns expressed by European businesses. To ensure market access, the European Union works cooperatively with the Chinese authorities to increase transparency and improve the implementation of IP practice and enforcement. IPK China also supports the EU-China IP dialogue mechanism and works to raise awareness on the importance of IP in the region. IPK China and CAASA have been co-organizing annual activities since 2018 to exchange Chinese and European perspectives on common topics regarding IPR protection, online, and innovation. This year, we're having two webinars, one yesterday and one today, and an in-person seminar in December in Beijing. So today is our second day of the webinar, and our experts today will bring different perspectives on the new trends on the e-commerce field for IPR protection. We will start with an e-commerce platform perspective at the hand of Michael Chu from Pinduoduo. Welcome, Michael.
Thank you. Ladies and gentlemen, good morning to the attendees in Europe and good afternoon to the attendees in China. And I'm Michael Chu, Senior Counsel of Compliance and IP at Pinduoduo. So first, I would like to thank CAASA and IPK for the invitation and opportunity to this sharing. So it is the second year Pinduoduo joined this forum, and it provides a great platform for stakeholders in China and Europe to connect. Everyone knows that the e-commerce industry is rapidly evolving, and it is essential for all participants in this category or industry to come together and to discuss issues and find solutions. Today, it's my pleasure to share with you on the new formats of e-commerce and also the IP protection challenges that posed on these new formats. So let's talk about Pinduoduo. Pinduoduo is now China's second largest e-commerce platform by users, with over 730 million active buyers. In the last 12 months, the transaction took place on our platform reached 214 billion in value. So each day, there were over 70 million, that's 1 out of 3 parcels every day, deliver that carrying products bought on the Pinduoduo platforms. We attribute our success to 2 factors. So one being the commitment to create value for consumers, and the other being our innovative model that transform online shopping into a dynamic social experience, providing consumers a fun and interactive experience. So like what our name means, we hope to bring consumers together with more saving and more fun. Pinduoduo was a product that born from the migration of people from desktop to mobile. It was built to be a consumer-oriented platform. Our app relies on its algorithm to recommend and feed the most suitable products to each user and for users to share and recommend what they like with each other. So when people come to our app to shop, it's more like offline shopping in a large shopping mall. They stroll and browse without any specific item in mind. Most of them focus on the window display product or top selling products put forward by stores. So when they come across something that's interesting or that they like, they would want to share them with their friends or recommend it to their friends. This is actually very different from the traditional e-commerce platform, which often treated e-commerce as a sourcing process between 2 parties. So traditional platforms were built to be targeted, oriented, and focus on efficiency. The platform indexes each product to allow users search for the product they already have in mind, either by keyword search or by category search. So the assumption behind is that people know what they want when they shop. The key for the traditional search-based model is to have as many SKU as possible so that when people search for an item, they can find it. It is this recommendation-based and social interactive experience that captures consumers to use Pinduoduo. And we also believe that we can make use of this unique model and chose to take a more proactive approach to protect intellectual property rights and combat counterfeits. So because gaining users' trust, having them more engaged with our platform, making accurate recommendations, and encouraging social sharing among our users are of fundamental importance to our business. The presence of any counterfeit product or just the mere reputation of selling counterfeits will severely undermine PDD's commercial objective. So if we want to create a clean and safe ecosystem that attracts good merchants and good consumers in bulk, we must take anti-counterfeit work as our top priorities. So over the years, we implement various innovative measures built on 3 core principles. The first one being take advantage of proactive enforcement. The second is to make use of technology. And the third being to punish the infringers while we reward the good merchants. Among them, we pioneer a number of measures which receive quite positive feedbacks from rights holders and consumers. So the first one would be the 10 times compensation, which we implement at the very beginning of our business. So we are the first e-commerce platform to implement and strictly enforce the 10 times compensation policy. It sets a new bar to deter counterfeit sellers and protect consumers. So if a merchant is confirmed through the test purchase process to have sold counterfeit products, the platform rules impose on the merchant an obligation to pay 10 times the value of the historical sales of that product on the platform as compensation to all consumers that bought the product in the past, regardless of whether such consumers has filed any complaint or not. So the entire proceeds goes to consumer, and Pinduoduo does not make money from it. As time shows, this measure has served to be a very strong deterrent that make most of the merchants not willing to take any risk to sell counterfeit on the platform. The second one would be the brand care program that we launched in 2019. We launched this program, which soon became a key plank in our proactive strategy to combat counterfeiting. Given that counterfeiters are attracted to brands that are more popular among consumers, we selected 1,000 brands that are best known to consumers in China to take part in the brand care program. So the platform reviews and adds brand each year. Rather than employing a one-size-fits-all policy, Pinduoduo uses a bespoke approach incorporating technology and maintaining customized screening rules for each brand that proactively detect and block counterfeit listing, and that are automatically applied to each new listing as well. So in developing these rules, Pinduoduo studied the pattern of infringement, particular to each brand, and undertook market surveys and brand interviews to understand the conditions unique to these brands. The consequence is that consumer won't see most counterfeit listing because the firm's algorithm already blocked this listing that run afoul of these custom-built screening rules. And those counterfeiters who manage to bypass these rules must contend with post-listing screening model as well that use a range of other criteria, including buyer rating and feedback to flag counterfeit listing for takedown. So in last year, we can see that the brand care program covered 522 brands. And this year, we expand this successful program to cover more than 700 brands. And in 5 years' time, we developed an intellectual property protection system that integrates well into our business model. So the closed loop system monitors merchants and merchandise before they enter into our e-commerce platform and until they exit it. So it starts with the merchant when they try to enter our platform. As you can see on the slide, the top left-hand side, our merchant onboarding system verifies both the applicant's personal identification documents, company registration documents, and other necessary license and permits. So the system is integrated with China's nationwide public security database to verify the authenticity of the personal identification documents. So the merchant applicant must match with their submitted identification documents through our live facial recognition procedures. So these measures prevent applicants from using fabricated ID to create merchants accounts. So applicant must also submit for review necessary licensing during the onboarding process. So if any prospective merchant fails in any step of the onboarding procedure, it cannot open a merchant account on our platform. The platform then implements a merchant rating system that rates merchants by various factors, so including customer review, sales volumes, etc. So merchants with lower ratings are subject to higher governance or stringent governance. That means to more monitoring, such as test purchases conducted by our platform, and their products may be demoted in the recommendation ranking or even blocked from the platform. So we maintain a blacklist for unscrupulous merchants, including the merchants selling counterfeits. So blacklisted merchants and their associates can never open any merchant accounts on the platform again. So even after merchant register on our platform, they are not free to list their products. Instead, they must make listing applications beforehand. Rather than waiting to assess compliance on an exposed basis, we actually deploy pre-existing tools to proactively detect and block products for counterfeit and other infringing activities. So based on our analysis and sometimes with the assistance of brand owners, Pinduoduo formulates parameters to be used in identifying infringing product through computer algorithms. Any product listing running afoul of the applicable screening rule is intercepted and blocked. So user will never see that product listing from the very beginning. And because of our unique social commerce model, most of our users make purchases through browsing our personalized recommendation feeds. That being said, our entire proactive anti-counterfeiting measures are not just limited to recommendations feeds only, but are applied to all product listings offered on our platform. So we also invested heavily in post-listing takedown procedures that draw on internal tools. So our post-listing models proactively screen for infringing activities or types of counterfeits that elude the pre-listing rules. So either because the product passed the screening threshold by margin, or because the counterfeiter had developed some new tricks. So what we do is that we conduct both manual and system screening on the platform, seeing all these products listed on a platform based on various inputs. For example, negative feedbacks from buyers, also from report, and another channel will be the notice from a lot of rights holders. And then we recalibrate our measures to catch or identify these counterfeit products and take down such products. We also have our own secret purchase program for authenticity check. So in order to avoid alerting counterfeiter, we have built a team of secret buyers located all over the country to help to conduct these secret purchases. So we continuously identify questionable behavior patterns by merchants, which affect their scores. Lower scores lead to less chance of recommendation and less traffic. For instance, so if a merchant opens multiple stores and each store only has 1 or 2 SKUs, that raises a red flag to us. We analyze data to identify related stores and merchants. So if we ever identify one merchant for selling counterfeits, any store that is connected to this merchant by name, ID number, bank account information is flagged for us to take another closer look. Such an aggressive, proactive anti-counterfeiting program gave us some very encouraging results. So as you can see, for the from January 1st to July 31st, 2020, in these 7 months, we have already proactively blocked over 95 million product listing applications and remove over 750,000 suspected products on our platform. And due to all this blocking and interception removal, we have sanctioned over 885,000 merchants selling such products. So as a technology-driven platform, we develop machine learning authenticity rating system. So we identify counterfeit product every day through our pre and post listing screenings. So brand owners' complaints on our IP portal and users' complaints on our apps. All these information of the counterfeit product will be inputted to the authenticity rating system. So the system will analyze the information and find products having the same or similar characteristics. The rating significantly help us to reduce the time to combing through potential counterfeit products. So our team, the enforcement team, would look at these products according to the authenticity rating that they have been given by the system and confirm if they are counterfeit or not. Given that we have over billions of products on our platform, so these measures significantly help our team to quickly identify the more susceptible or more suspicious counterfeit product on the platform and take prompt actions against them. As you can see from the slide right now, once our system alerted a highly risky counterfeit product, we are able to remove them within 30 minutes. So the system will keep improving on accuracy and effectiveness as the database grows, leading to more faster takedown as well. At the same time, we also provide convenient and efficient notice channel to all the rights holders. Our IP protection portal, which is ipp.pinduoduo.com, was launched in the end of 2018 and in early 2019. So it is designed to be simple and straightforward. So brand owner only need to open an account and register their IP rights. After registration, they are free to make IP infringement complaint of their registered IP right, which covers trademark, patent, and copyrights against any merchant on our platform. So brand owner now only needs to register their IP once instead of submitting proof every time they make a complaint. Also, they can compile like 200 product listing in one complaint. So these measures actually help the brand holder to reduce their time and their effort that need to be put in to submit one complaint. This has been shown by results. Right now, each month, we are handling over 200,000 complaints. And that is a significant increase comparing to before the launch of the IP protection platform, which we use email system to accept complaint. And at that time, we can only accept like over 10,000 or between 20 to 30,000 complaints each month. So apart from the measure we took to increase the enhanced efficiency of the IP protection platform, we also take into consideration that there are brands owners or rights holders that do not have a local team in China and may not be Chinese fluent. That's why in mid-2019 we launched the English versions of the IP protection platform, which make available to all the rights holders overseas, and they are now allowed to open a register platform, register an account on the platform, and also to look at the progress of each complaint and also understand the reasons for compliance or the reasons for rejections for their complaints. We also make available our policies on our secret purchases and our IP protection on the front page of the platform as well, to facilitate or to let them understand more about our platform. As of right now, there are already over 140,000 rights holder registered on our IP protection platform. And we welcome all rights holders to use such channel to protect their rights. And also all this information that they submitted and registered on our platform would all be able to in turn help our proactive measures. We will consider those informations and try to integrate them in our proactive anti-counterfeiting measures, including the brand care program. So this year, despite the unprecedented pandemic that halted many activities, we actually step up our efforts on offline enforcement cooperation with rights holders. So in addition to working directly with hundreds of brands, we actively collaborated with the law enforcement to combat counterfeit products. We provided leads that enable authorities to investigate and prosecute potential counterfeit merchants and manufacturers, involving over 700 million renminbi worth of counterfeit sales. So in July 2020, we held a joint enforcement operation with Johnson & Johnson, which resulted in the arrest of 3 counterfeiter suspects and seizure of over 50 cartons of suspected counterfeit baby skin care products. And the investigation unveiled and stopped a counterfeit ring operating across multiple e-commerce platforms as well. And there is another sample case which we did in June 2020 with Sporting, which we are able to apprehend the 11 suspects and seized fake product with estimated value of over $700,000. China's e-commerce market has developed rapidly in recent years, and there is little doubt that this evolution would continue. So there are new features launched every month, and without a doubt, COVID has drastically changed the landscape of e-commerce. So we remained committed to creating a safe and trusted shopping environment for the consumers. And we believe that collaborations among all stakeholders is the only way to achieve that. Over the past year, we have actively promoted dialogues on key issues and best practices on IP protections in the e-commerce sector. So to keep stakeholders updated on the latest features and results of our IP protection programs, we started our monthly IP newsletter in February this year. So every month, in addition to the regular updates on the latest development on IP protection on our platform and also in China's e-commerce industry, the newsletter also has a feature article introducing in detail one specific IP protection measure or two we make available on our platform so that rights holder can reach out to us or continue the discussion with us on how to better use the tools that's available on our platform and improve what we call the counterfeit-free rates on our platform of their brands. So in August 2020, we published a white paper on the prospects, challenges, and best practices of IP protection in China's e-commerce industry. So we explain our philosophy on IP protection, share our insights on best practices, as well as the challenges and hurdles our platform and the industry face. We hope that this white paper could generate further constructive dialogues and actions towards a cleaner online marketplace. So I really recommend to ask every attendee, if you have the chance, go check out the white paper that is available on our Content Hub. And if you have any comments or recommendation feedback, please feel free to get back to us, and we are happy to discuss in more details. We also launched a podcast series named IP Matters that focus on industry experts' views on IP protection in China, so particularly in the e-commerce industry. We interview experts from academia, regulators, platforms, brands, trade associations, and professional firms from all over the world to share their personal experience and expertise in fighting counterfeits online and their unique perspective and views on the future direction of the industry. In this industry, so new features and new forms are coming up every now and then, like every month. So as you can see on the slide, so these features or elements have made their debuts, trying to satisfy consumers' ever-changing needs this year. This is just a few examples, as we can see. And while these new features create opportunities, they often also pose challenges to the existing risk control and governance mechanism. One that must mention would be the live streaming. As I'm sure if you will agree, the most popular feature this year that attract a lot of attention. So it is not only an additional tool to the merchants of e-commerce platforms to promote their products, it also opens a way for social media to step into the e-commerce industry, as the internet celebrities active in the social media can now monetize their popularity and fan base by selling goods to the audience. So to Pinduoduo, we embrace live streaming as it is what consumers want, and it enriches the entire shopping experience. That said, we also realize the challenges live streaming pose on our existing anti-counterfeiting measures. First of all, it is difficult to monitor. So live streaming is spontaneous. Merchant can start live streaming anytime and close it anytime. So there is no schedules on the product that will be offered during the live streaming. And therefore very difficult for our industry experts and also for the brand owners to monitor all the live streaming 24 hours a day. Secondly, it is difficult to screen. As I just mentioned previously, we have a couple of different measures trying to screen or identify counterfeits by textual analysis, by image recognitions, and also by syntax analysis. Also include our authenticity rating system, right? But live streaming is totally different because it is all moving pictures. First, it is very difficult to apply image recognition technology to moving pictures due to the ever-changing contrast, resolutions, and angles of the trademark that may be on the product or maybe in the video. Also, live streaming makes all these keyword searches and textual analysis become useless, because instead of words, live streaming is all about voices. And voice recognitions in anti-counterfeiting is still a new area that need explorations and also developments. The third would be the difficulty to preserve evidence. Some counterfeit merchants would only make the product listing available during the live streaming and will remove those product listing immediately afterwards. So this makes it very difficult to nail down those counterfeiter and prove them selling counterfeit, because by that time, we do not have the products in hand. We cannot conduct secret purchases to confirm the authenticity of such product listing. So there would be a missing link in our evidence chain that we are able to prove in front of the court or the law enforcement that such counterfeiter are selling counterfeits. And as mentioned, live streaming shows the way for social media, and it is quite common that the live streaming was conducted on a social media platform while the product listing provided were directed to an e-commerce platform. So this arrangement actually was exploited by the counterfeiter. What they do is that they describe the counterfeit products during the live streaming and leave minimal information on the e-commerce platform. In this way, they are able to avoid all the proactive anti-counterfeiting measure or screening rules posed by the e-commerce platform, because from the platform end, they can see only minimal information of the products, which contains no counterfeit traits. The counterfeit traits instead were mentioned or described during the live streaming on another platform owned by another company. So the inter-platform barrier actually facilitate the counterfeiter to conduct counterfeit sales. We Pinduoduo took a few steps to stop or to to prevent counterfeit from being sold during live streaming. This year, we have established a dedicated team to patrol live streaming on our platform, and also we make available the complaint channel to all viewers to allow them, or they can report or complain suspected counterfeit products they see during live streaming, which we will follow up closely after we receive such complaints and look into if there is any infringement during the live streaming process. And the advantage of the e-commerce platform is that still all products that offer during live streaming has to be subject to the same set of merchant vetting procedures, pre and post listing screening rules, secret purchases that we built over the years, because at the end of the day, the live streaming is still promoting the products that's been offered on our platform instead of on some other platforms. So our existing system still apply to them like other products that has been offered on our platform. And thirdly, we also recorded every live streaming to make sure that evidence is adequately preserved for the post-reviewed, and also to be used as evidence for the civil and criminal actions if the brand owners ever request such evidence, or if the law enforcement agency ever requests for such evidence. We believe that these measures are able to reduce the counterfeit being offered during the live streaming process, but we also have to admit that there are a lot that need to be developed to cover this live streaming area, to make it, to ensure it as a clean and safe environment. This is just like a lot of other new features and new element that will be coming up, and we can foresee in the next year or in the next few years. So that would be my presentation, and thank you all for listening in. I will hand it back to you, Andrea.
Thank you very much, Michael. That was very interesting. Actually, yesterday we discussed quite a bit about live streaming, but without having any specific examples. We were just talking with Reinhard, who's a lawyer, about the legal implications, but we in our practice, in his practice, he didn't have found any example. So that was extremely informative. So now the floor is open for questions. So as you can see, there's the chat box where you can post your question in either English or Chinese, and I will read it to Michael, or he can see it too. I think David might have a question. So the question says, Michael, Hannah Ryder introduced a table yesterday in her presentation showing there were inconsistencies in platforms measures. The data was from 2 years ago, if I understood well. It shows Pinduoduo didn't have its own portal. From your presentation, I understand you now have it and did not apply 3 strikes policy. What is the situation today?
Oh, yeah, I also saw that yesterday. Thank you so much for bringing it up. Yeah, we have our own portal that interact with rights holder. As I have just introduced, that would be the ipp.pinduoduo.com. I believe by the time Hannah did her research, it may not be readily available yet because it was only made available in early 2019. Now it becomes more mature, and as I said, there are already 140,000 rights holders that have completed their registration on it and already using it on a day-to-day basis. Our target or our objective is to continue to improve on the functionality and the efficiency of the platform or the portal, so that rights holder it would make it more easier for the rights holder to submit complaints and stop any infringement of their IP rights. For the 3 strikes policy, yes, we don't have a 3 strikes policies. What we are doing right now is doing brand targeted ban on the merchant. So what we are saying is that if we found an infringement, a merchant selling counterfeit of specific brands, we will impose what we call a lockup to stop them from selling products of such brands, in order to prevent any further or repeated infringement done by such merchants. Someone would call that a one-strike policy, but that's not exactly accurate. The merchant would still be allowed to sell on our platform, but just not the brands that they conducted or they have infringed before.
Would they ever be allowed to, for instance, get back to sell the said brand, or is it a terminal decision on this specific brand they were counterfeiting?
We are conducting this as a pilot program. Our current approach is that we are setting it indefinitely, that the merchant would be banned forever. But we will review the situations, and we will also listen to all stakeholders' feedback to see what is the appropriate approach.
Okay. We have another question.
That would be the knockoff products. Knockoff products, we actually have an internal team to evaluate if such knockoff product, or what we call in Chinese the shanzai product, has actually caused confusion to the consumers. If we consider or determine that they causes confusions to the consumers, which make them think or mislead them to think that they are buying the other branded products, we will consider such as an infringed product, and would take actions against them, including removal of the product links or request them to rectify their infringement.
Just for the English speakers, the question was how to deal with infringing products of look-alike or copycats in the platform. So if there's other questions, we're still here. David says, you mentioned patrol teams that monitor live streaming sales events. How many people do work in these patrol teams? And also I would add, how often do they patrol? Is it choose randomly, or choose rather large live streaming events, or how does that work?
What we are doing, just like how we build up the database of a lot of infringement evidence or infringement patterns, is that we have an internal team to be doing this, and also we are trying to contract out this kind of work to service provider to help us to conduct the patrolling as well. One of the reasons is that we can do it in a larger scale and in a 24 hours frequency. I understand that my internal patrolling team or the team that's monitoring the service provider is around 10 to 20 personnel. I'm not sure about the number of persons that we contracted under our service agent.
Thank you, understood. So seeing if there are any other questions from my side, I think then we could therefore go to the break. Thank you so much, Michael. That was really interesting.
Thank you. It's my pleasure.
Thank you. PDD is using PinPie besides some brand names, which makes it look like an authorized store by right owners. However, if you look in the goods, they are from different stores. I guess those are not licensed by right owners, but we will need a question.
We do have this PinPie with the brand tag, which is literally, that's a tag of the two words PinPie or the word brands next to some of the products. The tag is actually trying to signify that these brand products are actually from popular brands, and also quite often or always these products that carrying the brand tag has been subject to a higher standard of review by us in connection with their authenticity. So it actually gives more comfort to the consumers or users that they can buy these products with more confidence. I will have to disagree that such tag would mislead the consumer to think that it is an authorized store, because as rightly point out, these tag can be tagged on any stores, and the store's names will still be displayed to all the consumers and users according to our classification system, which means that they will show as flagship store or authorized store or just ordinary stores. To our experience, users will still refer to the name of store to determine whether it is a formally authorized store or just a normal retailer, instead of just looking at the brand tag.
The question was if the brand owner opens a flagship store, then the products will be taken out from that service, or they will still stay on the service. From what I see, the first question.
Okay, so if the brand owner decides that's two different matters. The brand tag, as we said, it ties to the brands itself. It does not tie to any merchants or any store. So even if the brand owners decide to open an official flagship store, the brand tag will still be used on the brand products offered by other legitimate merchants, which we have imposed, or we have reviewed their product sourcing and also their historical sales and their merchant rating that we collect on our platform.
And last question from Chris Lee. Regarding the knockoff, does PDD need any official decision or judgment as the evidence for takedown action to be uploaded to your system?
So if the knockoff product, also if a brand owner complains about a knockoff product, they will need official decisions, or that's necessary for the takedown actions, in short.
Okay, great, thank you. That was quite lively set of questions. Well, Michael will stay around, and when we do open to the second set of questions after Rieko's presentation, there's always good to have a conversation between them. So we are now going to go for a 5 minutes quick break, and we'll be back later for a focus on the cosmetic and personal care products industry. So welcome back from the break. So with our next speaker, we're going to take, as mentioned before, a narrower, smaller focus, and see the changes and challenges business from the cosmetics and personal care sector experience. Our speaker is Rieko Michishita, partner at Bird & Bird. Go ahead, Rieko.
Good afternoon, and a good morning, and a good night, wherever you are in the world. Welcome to my office. My name is Rieko. Rieko Michishita. I'm an IP partner of Bird & Bird and Beijing office. I'm born and raised in Japan, but I moved to Beijing, China about 25 years ago. I've been working in the IP field for 17 years. My lecture today will focus on the cosmetic industry. It's going to be 30 minutes, probably fast-paced interactive lectures. So if you have any questions, and send me by text, or Andrea can interact me in the. So I would like to start as a first sessions at the case studies. And then second part, I would like to talk a little bit about strategy. So I'm going to introduce 5 cases that's a published civil action, civil litigations involving cosmetic companies. So the first case I would like to introduce is Herbicine. I don't know if you have heard about this brand, but this is one of Germany's oldest brand and famous for her herbal products. So the Herbicine Cosmetic had a Herbicine at the house mark registered in China, but start finding a lot of counterfeit products on e-commerce platform, and including Pinduoduo. Pinduoduo is similar to Taobao, Alibaba, or JD.com, but they are very popular, and it's cheaper. Some consumers said it's cheaper than Taobao or Alibaba or even JD. So the Herbicines also lies its trademark to Zhaoxiang Cosmetic Trading Shanghai Co. Limited. So this Shanghai company sued Zhou Xixiang as a Chinese individual selling a lot of cosmetic counterfeit Herbicine hand cream on Pinduoduo, and Shanghai Human Information Technology run the Pinduoduo platform. So there is a two defendants, but the one action against Shanghai Human was withdrawn because the Pinduoduo agreed to remove the counterfeit product from their platform. So they pursue the litigation against the individual. At the end, the court found that the trademark infringements. So it's quite straightforward counterfeit issues. The damages they found the court awarded is quite low. Economic loss is only 8,000, and the reasonable expense to stop infringement was just 4,000. Probably it costs more than 4,000 to file litigations. So the case was filed in August 2019. The first instant judgments were rendered just a little over 6 months, but the damage was really, really low. It's very common in e-commerce related, counterfeit related litigation case. The second case is L'Oreal versus Li Yu. So this case is more interesting. A Chinese chemical company called Guangzhou Wansha Fine Chemical registered Chinese version of Kiehl's in Chinese. It's called Qiashi in several categories and classes, and sold cosmetic product under the name of Qiashi. So this is not the pure counterfeit problem. They have their own product, but they put a Kiehl's Chinese name as their brand. And not just the Guangzhou Wansha Fine Chemical registered a Chinese name of the Kiehl's, and the legal representative also registered other Qiashi related marks. They further put an effort to establish a company in Hong Kong called USA Tears International Group Limited. Guangzhou Wansha and Li has nothing to do with the USA, but they put the USA in the company name in Hong Kong. And then Cheers, in its translations, a Chinese name registered in Hong Kong was actually Qiashi. So America, US, Kiehl's International Group Limited. So so it's quite confusing. So what happened is, so this company acquired a Qiashi registration in China and they sued Kiehl's, L'Oreal China, and then Baidu Technology as a defendant for trademark infringement. They say the L'Oreal China and Baidu use their registered trademark on their, they use Baidu brand zone and paid listing. I don't know if you're familiar with the Baidu brand zone and a pay listing. Baidu brand zone is a section located at the top of the Baidu search result. It offers a super large space for display and comprehensive promote the brand by promoting information in text and pictures or video and other forms of advertisement. Is quite effective way to do the advertisement or promotions. And the paid listing is also known as a pay-per-click service. It's a type of online promotion that pays according to the effect. So they use a 切尔实 Chinese as a keyword on the Baidu brand zone and the paid listing. So they claim that's a trademark use. Therefore, Baidu and L'Oreal infringe their registered trademark. So L'Oreal's argument was 切尔实 was used by Kiehl's first in Taiwan and Hong Kong before the plaintiff filed application for 切尔实 in China. So they started using in Taiwan and Hong Kong in 2004, but the plaintiff applied a year later. So the prior use defense and also the 切尔实 mark was opposed by L'Oreal. The use of 切尔实 on Baidu, brand zone, and a pay listing are not a trademark use, and they didn't have a bad faith in using those keywords. So co-examine, but they found the 切尔实 registered trademark was valid when the litigation was filed. So it's L'Oreal's argument in saying they were opposed it's not a valid defense. But court further examined the prior use defense. They recognize the L'Oreal's that actually start using the 切尔实 in Taiwan and Hong Kong. And because internet 切尔实 the use of the 切尔实 in Taiwan and Hong Kong markets could be accessible from a mainland China, so they could be regarded as a prior use in mainland China as well. So the court recognized the prior use defense and further examined whether L'Oreal had that faith in using the 切尔实. So L'Oreal's there was no evidence provided by the plaintiff to show L'Oreal actually had a malice intent and try to confuse consumer. L'Oreal's kills from with plaintiff's product. So the court found that no infringement and that there is no infringement. Therefore, Baidu doesn't also infringe 切尔实. So this is an interesting case. It's not just the counterfeit issues. So this is a plaintiff's website now. They still use 切尔实. I don't know if you can see. They actually still use the Chinese name 切尔实, but the Kiehl's changed the Chinese name to 可眼实. So they no longer use 切尔实. So I would like to go to the next case. Matisse. It's a French skincare brand. The brand owner is called Mark Line. So this is the fact. So in 1996, Mark Line registered Matisse, M-A-T-I-S, on a cosmetic-related product. Mark Line has found many stores selling the counterfeit Matisse on Taobao. Mark Line has continuously filed complaints with the Taobao takedown request with Taobao, asking to remove all the linked infringing product and close down the infringing store, including the store named Charm Key. Charm Key is operated by Liu Dechen, that's the defendant, the most infringing Matisse products among the store. So Mark Line was very unsatisfied with the response from Taobao and Liu Markline filed a lawsuit. So they actually sued both the seller as well as the Taobao. Markline was unsatisfied with the Taobao because they unreasonably they felt they provided enough evidence to show the product they Liu Dechen is selling is counterfeit, but Taobao only agrees to remove a few links, and most of the links are not removed. And they requested Mark clients to provide further evidence. That means that by sample from each link and verify whether it is counterfeit or not, and provide verification letters. If there are thousands of the links is selling the counterfeit, it's quite unreasonable to request the brand owner to buy one sample from each link and then test it and then verify and then issue the letter. That means a lot of work and a burden to the brand owner. But court found that Liu Dechen infringed Mark Line's trademark. That is quite straightforward. However, the court found Taobao didn't infringe according to the rules interpretations that's just provided on the slide. The rule stated an internet service provider bears a joint infringement liability when it knows or should have known the infringement and still provide internet service for the infringer or fail to take proper measures. So the mark line felt believed Taobao was informed by receiving the takedown notice. However, they only agreed to remove few links. The most of the links were not taken down. So the Taobao failed to take proper measure. But the court found Taobao had to fulfill its review obligations by the following steps. Step 1, Taobao checked the Liu Dechen's ID and they notified him of Taobao's IPR protection rules when Liu Dechen applied for opening the store on Taobao. Step 2, Taobao removed the links, some of the links, after they received Mark Line's takedown request. Step 3, Taobao gave Matisse a suggestion how to verify and approve counterfeit. Step 4, Taobao shut down the store at the end, but that was after the lawsuit was filed. I don't know the details of the case, the background of the case very well, but we found more and more difficult now than previous years. We feel like Taobao, not just the Taobao, Alibaba, and other platforms, for example, Pinduoduo and JD, they're very reluctant to take down counterfeit products or infringing products. They're more proactive. They didn't request so many proof of infringement or verifications before, but they are slower than before, or we found it very difficult to take down. We feel as a firm, there might be some protection for smaller business because it's a coronavirus hit the economy really hard, and the small business owner need to be protected. So that might be interesting moving forward, how platform operator will deal with these issues and how the court will view this, whether they will continue to find platform operators like Taobao how to fulfill its review obligations. So we'll wait to see. So this was judgments. It's a quite large amount of damages were awarded compared to first one. Next one is Christian Louboutin. Christian Louboutin is a famous French fashion designer and very famous for red sole high heel. That's his signature. But this case is cosmetics, lipsticks. So the Christian Louboutin registered this lipsticks, how to call it? It's a case as a design patent in China. But they found the infringing, the similar design lipsticks were sold online. As you can see on the slide, it looks quite similar. The left-hand side of the slide provide the names of the company provided on the infringing product. The package shows supervising company was Guangzhou Verteam Trading Company Co. Limited, and the manufacturing repackaged company is Guangzhou Benefit Cosmetic Co. Limited. Louboutin, the investigation found Guangzhou Omu Biotechnology was actually manufacturing lipstick itself. So the main issue the court had to decide was how to determine which entity manufactured and sold infringing products. So which entity will be liable for infringement. So the court decided the case according to the Supreme Court rules that provided that any enterprise or individual whose name, trademark, or other identifiable mark is embodied on the product and indicate is a manufacturer of the product is seen as product manufacturer as is stipulated in Article 122 of the General Principle of Civil Law, and the producer as is stipulated in the law of the Product Quality Law. So although the package say is Guangzhou Verteam Trading Co. Limited, its supervising company, we not quite sure what that mean. Is supervising just supervising, is not actually conducting manufacturing and the sales. But the court said, no, your name is on there on the packages. And regardless of what it said on the package, your name is on the package. So we regard you as a manufacturer and the sales of the product. So the two companies were found manufacturing and seller of the infringing product. But Guangzhou Omu Biotechnology was not found infringing because they were providing just lipsticks itself. They were not aware the lipstick will be used on the infringing product. That was quite interesting. So this company, the legal representative of Guangzhou Verteam, his name is Shen Yuze. He also had design patent register that's quite similar to Christian Louboutin's patent, design patent. Yeah, that's also interesting. So they're not just a pure copying. So this is a judgment. The court ordered two companies to stop infringement and destroy molds and other manufacturing tools and destroy stock of the infringing product and finished product as well. And the order two defendants jointly held liable for losses of 300,000 renminbi and reasonable expenses to stop the infringement. That's totaling it 40,000 renminbi. So the fifth case I would like to introduce is, it's hard to read this company name, I apologize. So this is quite famous French brand again, that's called Aven. I hope I pronounced correctly. So the French company registered Aven and other related series of marks in China. Aven products in China are only sold at the special official Aven counters. They found Changsha Huiji E-commerce Co. Limited uses words such as Advent China official website and the Advent China Mall on its website, where some images, text are the exactly same as those on the Advent's official website. They examine the purchase sample and they confirm that's a genuine product. But because French company believe those genuine product can only be sold through the official counter of the Advent products. So they sued on the 2 counts, trademark infringements and unfair competitions. So the court considered whether the Changsha Huiji e-commerce, the act constituted trademark infringement, and the court said no. Why they said no? Because after the Advent product was sold, French company has no right to prohibit others from reselling the product. That's called trademark rights are exhausted. And then Advent products sold by Changsha Hui, the French company also confirmed that's genuine, thus did not constitute trademark infringement. However, Changsha Huiji's conduct constituted unfair competition due to its use of the images and the text taken from Advent's website, misleading consumer to believe Changsha Huiji had a licensed relationship with Advent, thus gaining unfair competitive advantages. That's quite an interesting case. This is a judgment. So these are the cases are just the tip of the iceberg. These cases just show get some flavor of what counterfeit issues are, but there are overwhelmingly large number of counterfeit out there. It's impossible to eliminate all counterfeit, and don't even try. But what to do? There are issues. So unless your company has unlimited budget and unlimited resources to deal with the counterfeit issues, I recommend simple steps that might help. It's not perfect answer for every situation, but that will give you some ways to navigate through difficult waters in China. So there are 3 steps. I hope it's useful. The first one is quite interesting. It's a correctly characterize a case. I will discuss in details. And the second one is two-wheel approach. I always recommend my clients. Tip 3 is set your own priorities and create simple flowcharts so everyone can follow. So tip 1, correctly characterize a case. What that means, when I started my career 17 years ago, all we did was straightforward anti-counterfeit cases. So mostly the exact copies of the famous brand. My job at the time was to chase after counterfeiters, and if we find and we raid factories or stores, retail store or wholesale markets, then seize the counterfeit product and then destroy at the end. So that's all we did day and night. But counterfeit nowadays, as you saw in case studies, it's not straightforward, more complicating. For example, similar look and feel and not exact copies make things very difficult because maybe they don't use your registered trademark, but they copy enough elements of the design from your package or product. They make it look like similar, but you don't have legal basis to take actions. Or the other side has the counterfeiter register your mark, like a Kiehl's case. And in the Christian Louboutin's case, they even register design as their own. or they even file patents of your technologies as their own patents, or they copy your package design or advertisement materials with the Copyright Protection Center and they get the copyright recordation certificate. Or some, they even set up a company with a name incorporating your mark, and oftentimes it's Chinese, and that you don't have the protections. Or domain name. Domain name could be your English brand name, Roman letter, or Chinese in pinyin, or creating a fake official website like Events Case. They use official website, flagship online store, official WeChat account. There is so many officials. And some copying a similar business model. It's very hard to protect the business model with the IP rights. We had a case even copied corporate structure that was quite effort on the counterfeiter. So our client's headquarters in Paris, their Asia headquarters in Hong Kong, their PRC regional headquarters in Shanghai. So the counterfeiter, not exact order, but they set up a company in Shanghai, very close to our client's regional headquarters. And then they set up a company in Hong Kong, as they call it Asia headquarters. Then they even took a further step to register a company in Paris. After we investigated, we found companies set up in Hong Kong and Paris or sham company, the shadow company. They don't actually operate, but when the counterfeiter promote themselves, they said they have a headquarters Paris and Hong Kong and Shanghai, and they sell similar products. They look like exactly like our clients. So that makes things more complicating. And now today's topics is e-commerce. That makes things more complicating because 10 years ago or 17 years ago when I started, we only need to look at the real market, and you don't need to think about virtual market. And even 10 years ago, when the e-commerce started booming, but a lot of clients said our products are sold only through the official counter, like Events Case. So they didn't pay much attention to the e-commerce market, virtual market. But now you cannot ignore, because a lot of products are sold online, or especially cosmetic, might take over the real market. So you need to do double, 2 times of the amount of work you need. So real market and the virtual market, that makes things more difficult. And in the cosmetic industry, the health risk is a real concern. And the counterfeit often have very bad quality that might harm consumers. That will eventually will harm a brand value. If they have the first time they buy your product and they have a bad experience, even that's a counterfeit product, they will never buy your product. And also the parallel imports, also the concern for cosmetics. It's difficult. It's probably my advice to my clients, when my clients come with these problems, their email subject line is counterfeit issues or counterfeit found in China, counterfeit found in Taobao. But when we break things down, it's not pure counterfeit. It's a lot of more complicating. But when you start using a word counterfeit, people think they remember the exact copy. So the business or salespeople expect you, legal team or IP team, whoever dealing with the counterfeit issues, IP issues, to solve this problem quickly and easily. So when you deal with the issues like the cases we just discussed, The business people or sales teams are not very happy with how you handle the cases, because although you put a lot of efforts and some success, but the business feels like a lack of speed, or why taking so long? Why so difficult to deal with a counterfeit? Because you need to explain this is not a counterfeit, pure counterfeit issues, more than that. So probably sometimes I have to tell my clients, stop using a word counterfeit and correctly characterize a case and discuss with the business or sales team up front so that everybody's on the same page. That will prepare you and also your team to handle irregularities you will encounter and deal with this type of the problems on especially online e-commerce platforms. The second is tip two, two wheels. You need to have a balanced two-wheel approach. It's quite simple. In order to move outward in the business, you need both the side, you need to have a right, you need to have an intellectual property acquired in China, and then you need to enforce it. So this slide shows type of the IPR available or type of the protections available in China. It's not rocket science. You need to see there are patents, design right. Design is a part of patent in China, and the copyright and the trademark. And if your products are famous, probably maybe um, able to get protection under unfair competition law. There is a merit and demerit in each right, but it's better to have as many rights as possible to protect your product. So this just some example of the um, IP rights that you could obtain or record in advance. So not just it's a look at it from the left side. The left side is outer package of the hair dye product of the L'Oreal. This could be protected as a design or copyright in China. The second is user guideline, for example. As you can see, user guideline also has a lot of illustrations and special pictures. It's taken by a special professional photographer. And those are could be protected as a copyright on each element or as a whole. And then right-hand side has application, the containers. Maybe not this particular product, but the container, if it's a unique and an artistic feature, could be protected as a design patent in China. And if there are patents printed on the containers and could be copyrighted. So I just need to mention about the copyright, and the copyright does not everybody knows copyright doesn't need to register to get the protections. But in order to file takedown requests with e-commerce platforms, you need some proof you have copyright in the product or package design or user guideline or website design. How to do that? You can simply record your copyright artworks with the Copyright Protection Center in advance. It takes long times to get certificate nowadays, so it's advisable to get it now to prepare for any future counterfeit issues. Hopefully it doesn't happen, but it's better to prepare because it takes several months to get the certificate. So the business might feel it's so slow to take down the product because you need to get the certificate. So the possible measures available in China is basically this. And as you can see on the slide, you can do the investigation, desktop investigations, and send the investigator to the counterfeiter or infringer's business premises. Then negotiation. I said negotiation, but it's a send notification letter or cease and desist letters. Unique to China, you can take administrative actions or if doesn't work, a judicial civil litigations. And also you can take a takedown request with directly with e-commerce platform operators. Or the last one, the wait and see, so you don't take any actions, but that's not advisable. Now you know the available measure, but in practice, it's very difficult to decide. So I usually recommend my clients, even to large organization or companies, you need to set the priorities because you will see a lot of counterfeits and report it, and or you find it. So you need to know the very easy way to categorize which type of the counterfeit or infringement issue you need to take action and what actions. So this is the one of the clients, the priority list. So they made very simple ones in an importance level high and medium low, and they set the evaluation criteria 1 to 4, 1 to 4, 1 to 4. So high is they must have some sort of intellectual property rights acquired for the product. And the middle and low, so they don't have intellectual property rights. And then it's a difference between high and medium is high maybe it's possible to take a litigation, and the medium no litigation options. And then once that you set the priority, then I recommend create a very simple model flowchart according to different level of importance, high, medium, low. To the professionals, maybe it looks too easy, too simple. It doesn't, maybe you think it's um, too simple. But in the larger corporations or any corporation needs some sort of a model flowchart to work with. So it's to share with everyone, not just the legal department, IP department, but also with the business. The people working in frontline, they need very clear guidance and expectations. So this will help you to manage everyone's expectations. So yeah, this is tips to take home, and this is my last slide. Thank you very much.
Thank you very much, Rieko. It was a very comprehensive and very interesting presentation.
Thank you.
Presentation of cases and further explanation on strategies of protecting IP specific for cosmetics. I'm going to open the floor to questions. Feel free to post them on the chat, and I will read them to Rieko. She will read them.
Compliment.
David says, you said that lately platforms are a bit more strict when it comes to notice and takedown. With your experiences of dealing with platforms, do you think introducing a collaborative approach in China, such as a memorandum of understanding that was discussed yesterday, could be helpful?
Yeah, definitely. So, we feel in the last few months and really, really difficult to get Taobao, even like Taobao and Alibaba has a great platform and a system been working very well for a long time. But because of coronavirus, the economies and situations, we feel all of a sudden it's process like is stopped. So we've been asked or we've been rejected for various reasons. They ask for verification letter. They never asked before for each link. So some of clients, like for example, like we have here, Hello Kitty, they have like 100 links of counterfeit. So we want to remove quickly. The client confirm they are counterfeiting products. That's sufficient before, but we've been asked to provide verification letter. Otherwise, they don't take down. And even some occasion we submitted a verification letter to the platform. They said it's not sufficient without giving a reason why it's not sufficient, because it's some of the verification method we use we cannot disclose because it's a confidential. And that was not the issue before, but that's the issue now. So I think the collaborative effort is to persuade those platforms, even the current economic circumstances, if it's an infringing product, they need to take down. So it's rather than individual brand owner request platform, it's better to collaborate in European companies or cosmetic brand working group as one, and to work with those platform provider is definitely useful, I think.
Thank you. Actually, Chris Lee from SNO has agreed with you that they're also experiencing much more difficulty to take down. And David follows up asking if could the representative of platforms present today answer and tell if there's a more difficult or not process for takedown. For instance, Michael from Pinduoduo. If you mind jumping in, sorry, you're put again on the spotlight today, knowing that JD and Alibaba were yesterday.
Yeah. Oh, I just realized I'm the only representative of platforms today.
There's
Okay,
Amazon also. There's Amazon. We could ask Amazon also there.
Oh, okay. So I guess Kona will be jumping in as well. So let me take a look at the question. So could the representatives of platform present today answer and tell how to ease the process as before? So that's a questions about the procedures. It's getting stranger recently. On PDD, we are not aware of this. We have taken the same approach in the past year. To our understanding, we realized that some platform may be taking a more stringent approach towards shopping festivals. On both reasons. One of the reasons is that indeed there are merchants which would take more aggressive or malicious complaints against some of the other merchants on the platform during that period of time, because as you can imagine, if one of the malicious merchants is able to take down the other merchant during the single day, that would be a great hit to the victim in terms of their revenues, because a lot of merchants make a significant percentage of their revenue on several days in China. That's the norm in China right now. These shopping festivals are key to the merchants. So that's one of the cases that we saw. And also there are cases that we need to, the platform have to take a stringent approach just to make sure that justice is done. So that would be another reason. But to PDD, we try to take a consistent approach on our IP protection platform. One of the reasons is that because we just launched not long ago, this IP protection platform. So we think that it is necessary to keep a consistent approach so that the rights holder can get familiar with the requirements, both on documentations and also on the technical side, like what kind of formats they have to produce, or what kind of link they have to produce on our platform, so that they can get familiar and can use our platform more efficiently.
Okay, that's interesting to know, especially, well, as you mentioned before during your presentation, Pinduoduo has a newer platform for takedown and for protection of IP. So it's interesting to see much of a newer approach, and hopefully it would get better after this year. So a question that I have, I mean, I don't know if there's, last question for Rieko from David. How do you deal for your clients with the new challenges of live streaming sales discussed by Michael earlier? For instance, sale of live streaming.
Wow.
Yeah.
Actually, to be honest, I haven't dealt with the cases involving live streaming. It's very, very new way of marketing products. It's interesting. Yes, I would like to know how. Sorry.
No problem. Actually, Michael presented on how they are dealing from the platform with the live streaming counterfeiting, and that was last year. Yesterday, we also had a question like on live stream.
Oh, okay. Okay.
And from the lawyer side, there were not yet cases to experience. But from the platform cases, Michael was explaining how they deal with the live streaming because there's such a boom, especially this year where you can, people were staying at home more, and I guess it was much more interactive to
yeah, that's another challenge
yeah.
we need to deal with. Yeah.
Yeah, that's again a good point to put forward, and memorandum of understanding or something that it's more flexible than a legislation where it's always a little bit of a change for legislature to close loopholes of new types of e-commerce and so on, especially such a technology that advances so fast. And yeah, it's
Yeah, we need to keep up with the technologies.
Yeah. All of us, yeah,
for sure.
I agree. I don't know if there's any more questions. Otherwise, we would head to the break. So thank you so much, Rieko, and thank you so much, Michael, for jumping in. And then we will.
My pleasure.
Thank you. We will continue. So later on, our next speakers will discuss more on matters of enforcement and new technologies and new challenges that encounter on the enforcement side of intellectual property rights. And we would have a speaker from Amazon, and then two speakers from the European Union Intellectual Property Office, UIPO Observatory. Thank you, and see you in 5 minutes. So welcome back to the last part of the seminar. Here in this part, we will have 3 speakers that will do the presentations back to back. And then we will have all the questions coming in at the end for the 3 speakers. And so to create a sort of also dialogue. So our next speakers will bring different viewpoints on new technology and strategies in IP protection at an enforcement level, as mentioned before. We will have Conan Chen, which is Senior Director of the Public Policy and Government Affairs at Amazon. And later on, we will have Erling Westergaard and Antoine Aubert, both experts at the UIPO Observatory. So go ahead, Conan.
Thank you, Andrea. So good morning, good afternoon. This is Conan Chen from Amazon, responsible for IP protection and leading the consumer trust program in Amazon. So first of all, I'd like to thank CAASA and IP Key China for the invitation for me to attend this roundtable discussion focusing on IP protection, enforcement, especially on the new, technology and skills to trace the bad actors in the online place. So considering that we have both attendees from China and European countries, and my deck is actually in English, so I would present my slides in Chinese.
Well, thank you. The third part of today's session is about new technologies and new strategies in fighting IP infringement. And I'm very happy to be here to share with you some of the new technologies and the new measures that are used. Amazon was established in the year 1995 by Jeff Bezos, and it was established in the garage of Mr. Bezos. At the very beginning, it was a book-selling company. From the first day, our mission is to become a customer-centered organization, and we hope that our customers can buy the thing they want to buy on our platform, and they can have the best experience. That is why we try to gain trust from consumers, and to maintain their trust. In order to do that, we invest a lot of resources to prevent counterfeited products on our platform. Let's see how we do this. Well, this is our brand protection program globally. We have Amazon brand registry, and we have automated brand protections, Project Zero transparency, as well as a report of violation. All those are tools available. Before I talked about details of those tools, I want to share with you a few numbers so that you understand the scope of our business. The first number is hundreds of millions of customers. We have hundreds of millions of customers all around the world, wherever they are, or wherever the products come from, consumers are assured of the quality of the product. And second number is millions of selling partners. We have millions of selling partners. We constantly come up with new tools to make sure that trustworthy sellers can register an account with us and to sell their products on our platform. And also we want to prevent illegal or counterfeiting products on our platform so that customers can get access to quality products at reasonable prices. The third number is billions of product updates daily. Every day we have to update over 5 billion products, including new listing as well as updates of existing products. That is why we need to have constant innovation to set up models to identify risky points. And how do we forecast and prevent risks? The answer is machine learning. Amazon has the most advanced machine learning technologies. We can identify risky points, identify the links so as to proactively prevent illegal or counterfeiting products. Compared with manual work, machine learning can identify behavior patterns that is hard for human to identify. For example, we have account verification. When sellers register an account with us, we can identify the sellers and verify all the documents provided by the seller. To some extent, we can prevent potential counterfeiters. Why only part of the counterfeiters? Because we have gray areas everywhere, gray areas and black industries, gray industries. For example, a lot of certificates as well as payment methods are available to counterfeiters. Well, potential counterfeiters may not use their real identity. They use the counterfeited products. They also use the fake identity. That is why we need to use all kinds of inputs. For example, the machine that the counterfeiters use to log on to the platform and other inputs so that we are well equipped to fight against counterfeiting products and counterfeiters. And once we identify a counterfeiter, whether we should shut down the entire account or only partly shut down the shop. And this is a live learning system. We definitely cannot avoid mistakes, but the mistakes will help us to prevent future mistakes. That is why machine learning can guarantee that we always are a step ahead of counterfeiters. We have investigators, we have scientists. They are critical to us. By combining machines with humans, we can fight against counterfeiters, and the machine learning can become increasingly smarter. When machine learning continues to evolve, we also have brand registry and other systems.
So what is brand registry? So the brand in the selling destination, for example, in US, will register a trademark in US, and that trademark will be registered in our system. So that will unlock the rest of the process for the seller, for example, to display your product, description of the product, to file complaints. And also we can proactively monitor for you violations. To obtain this registry, the seller or the brand will first have to provide registration trademark for the selling destination that you want the protection from Amazon. So the filing with the customs is the same concept. So you have to file information with the customs in order to get protected. And with Amazon, it's the same. So you have to register information with us. Starting 2017, we have launched brand registry, and over 350,000 brands have registered with us. For every notice of infringement, we have handled, and also over 100 suspected listings will be removed. So it's a proactive prevention. We also have a 24/7 response mechanism in place to investigate into those violations. Once you finish the registry, we will activate other protection measures for you. For example, we have the automated brand protection. So through machine learning, Amazon can leverage the information from the brand to do preventative monitoring. Will identify potential risks. This will include, for example, the protection for your trademarks, logos, text descriptions, and also when you create a product or product pricing, we will have protection measures activated for you as well, so that counterfeiters will have no space to violate or infringe your right. So over 6 billion suspicious information has been blocked or intercepted before getting listed into Amazon platform. Now let me talk about report of violation, or RAV in short. This is simple. So you register your brand with Amazon, and then after that, we will have a tool for you to report suspected violations to Amazon, and we'll take measures for you. It is very easy to use. So you can do one key search. So regardless of whether you are using US or Japanese Amazon, you can do keyword search, picture search. We also have the async number for every product, and you can use that number to search for violations. Also, we have customized filtering features. For example, by pricing, by location, by rating, you can do the filtering. Also, in the report records, you can see previously filed reports. In the complaint details, you can find details of that particular complaint. You can see the complaint ID, and then under that, you can see the IP information, the infringer, contact, name, address, email, etc. So it's very easy for you to get hold of the information that you need. Now let me talk about Transparency Program. Transparency Program is a program from Amazon that is for product tracing and authenticity verification. So we trace the product to make sure that the consumers and brands are protected. So what do we do with Transparency Program? So first, you need to register your product information into the Transparency Service database to get the service. After that, we'll send to sellers a serial number. So it's a number randomly generated with letters and symbols. So it's a QR code in the look. It's in the size of a coin size. So every product in the Transparency Program will have the QR code unique, and the brand will use that brand on the packaging of the product or integrate that into their packaging, either way. The fulfillment center of Amazon will scan the QR code to make sure that it's only the authentic product that will get delivered. The user can use the program to scan for authentication of the product as well. So that's a step for the consumers just to get assured that they are getting an authentic product. Now, let me share with you a group of data. Currently, globally, we have 7,500 brands that enrolled in this transparency program. This is the data for 2019. So we have for Fortune 500 brands, as well as some startup company brands that are registered in this program. Over 25,000 products are using this transparency code. And through this program, we have intercepted over 400,000 suspected counterfeits to get to the users. Now, let me talk about Project Zero. Project Zero is for the purpose of leveraging the resources from Amazon and brand to help brands to get rid of counterfeits so that we bring down the counterfeits or infringement totally. This is in connection to the automated protection service and also the transparency program service. It has additional features as well called self-service counterfeit removal.
品牌方它不再需
So
要
the brand will no longer need to contact Amazon to get the counterfeit removed or taken down. So the self-service will allow them to remove the counterfeits by themselves. So here you see the interface. Once you are in Project Zero, this tool is made available to you. So there's the automated protection, there's the transparency service in this program. You fill in the information in this form, including your contact, including the suspected product description, the brand of that suspected product. Once you finish those steps, you can remove the product. So it really empowers the brand. But of course, that's based on the trust. So we have a rule here. If you abuse this tool, then you will be disqualified to use this tool. We always say that you need to stay ahead of your enemies. As a high-tech company, we have to always advance our technologies to stay ahead of those violators. Amazon this year has introduced new IPR protection measures. First is about the seller registry. Now we have a video verification. We always innovate to improve the experience for sellers. For new sellers, there are a high percentage of Amazon users. They can seamlessly connect to our platform by registering on the platform. And we also proactively prevent those violators to get to our platform. Now we have the remote video conference to do one-to-one video talk with the potential sellers to verify the ID information and the documentation, just to make sure that they are true. Now in US, UK, Japan, and China, we're piloting this program, and many potential sellers are responding positively. Of course, those counterfeiters will try to hide their information. The video one-on-one talk will actually somewhat deter them from getting onto our platform. Also, there's the whole removal of the suspected brands. So all of the products from the suspected brands will be removed one click. So we will look at information called repeated infringers. So once we identify those repeated infringers, we'll do removal of all its product one click, so that the right holder does not need to submit every link to us. So once you find that the brand has infringed upon the right holder's rights a couple of times, then we will list that person as repeated infringers. Then we can do one-click removal. But if it's occasional, then we'll look at case-by-case report to do individual handling. Because it's a removal of all the products for that brand, so it's been very effective and deterring. And of course, we do allow the infringer to counter-argue And of course, it's going to be really burdensome for you to get back into the platform. Also want to trace offline counterfeiting activities. This is actually how we get to the problem at the root. So we do offline investigation and also joint litigation with the brands. Currently, Amazon globally has worked with legal authorities on counterfeiting and infringement. We have worked with brand owners, right holders to go through legal procedures to chase down those violations. Viola, Bentley, Lightyeast, WannaGrow, Valentino are just a couple of brands that I want to mention here that are working with us to go through these legal procedures. Amazon China has also started to work with the Public Security Authority to submit infringing data to the public security authorities. So we are sparing no effort in combating counterfeiting and infringement. So we want to work with partners to really pull our resources together to get to the root of the problem, to really track down those counterfeiting activities at the very source. At the very beginning, maybe we can work with Amazon to do offline investigation of a seller, and then we can do test buy and authentication to collect evidence. We want to provide as much information as possible when we file notice. We also want to exchange information with Amazon to get investigators to get hold of the information and whole picture, and then we can do joint filing, civil or criminal. In China, Amazon has cross-border e-commerce. So there's the cross-border export and import. So we don't have China sellers selling to the China market. The local B2C or B2B is not available in China. So the cross-border means that it's having shops globally. So we help Chinese sellers to sell Chinese products to the rest of the world. And of course, you're going to see counterfeit issues. For example, recently at the customs, we've discovered a new way of counterfeiting. So they will have the FBA tag on their packaging. FBA stands for Fulfillment by Amazon. So the seller, the counterfeiting, the infringement seller tries to reduce the chances of being investigated by the customs because they think that FBA logo would tell the customs that it's from Amazon fulfillment and therefore less likely to be checked. And we find that some of those information on the packaging, including the logistics information, is totally fake. You cannot really even link those information to the real seller. And sometimes the logistics information is true. And if the logistics information is true, we will be able to work with the customs to trace down the infringing seller. But if the logistics information is fake, it's more difficult for us to trace down. I know that today we have with us representatives from customs and public security as well. So Amazon wants to work with authorities to really work on these issues, to really get rid of the cross-border counterfeiting activities.
Well, just as mentioned, we have worked in with those brands in the United States, and also we have regular exchange of ideas with industry associations. Actually, Amazon is a member of QBPC. We have been working together with organizations, government agencies, academic institutions, and we make joint efforts to create a better environment for IP protection. In the end, I want to again share with you a few numbers about our efforts in protecting IP. We invested over 500 million, and over 8,000 employees to fight fraud and abuse, and over 2.5 million bad actor accounts were stopped before they published a single listing sale, over 6 million suspected bad listings removed before they were published, and over 99.9% of products bags have not received a notice of potential counterfeit infringement. Well, those numbers prove that Amazon has made every effort to protect IP. We're going to continue our efforts in fighting infringement to increase IP protection, brand protection, and to protect the rights of IP holders. Thank you.
Thank you very much, Conan. That was very interesting. I invite you to stay online because we will, as mentioned before, we will do the Q&A at the end of the 3 presentations. So for people who would like to ask questions, please keep posting them on the chat. I will ask them at the end of the presentation from the 2 UIPO experts. So I think because we're talking about cross-border, it would make sense for, if I'm not wrong, for Erling to jump in and present on cross-border issues and so on. So I'll let you the floor, Erling.
Thank you very much. I hope you can hear me, and thank you for the invitation. I'm sharing my screen now, so you should see my slide. I can tell you my background for speaking you today is that I've been a Danish prosecutor for many years and worked with intellectual property crime and internet-related issues since 2006. And I had the honor 11 years ago to be the first prosecutor that was not Chinese to be given the chance to address prosecutors from all of the provinces of China, gathered together in one room to discuss intellectual property crime. And we have here in the EU IPO established a close cooperation with the Supreme People's Procuratorate, where we, up until the pandemic anyway, met once a year with the Chinese prosecutors working with intellectual property crime. So we are very, very happy with that and hope that the cooperation can continue when we are back to normal again. I will be talking mainly from a criminal perspective, and my colleague Antoine will take over and take a different perspective on things. But I'll just briefly touch a little bit upon some of the challenges that we're facing in cross-border e-commerce and how we have dealt with that in the European Union. A little bit about a topic that is becoming more and more relevant. It's data protection. It's really, well, it's certainly in Europe a very, very big topic. And then I will talk a little bit about how law enforcement in Europe is collecting evidence in regards to e-commerce. Now, what are some of the challenges with IPR and cross-border e-commerce? Well, it was already touched a little bit upon it in some of the previous speeches, but the territoriality of IP rights, of course, is important. And the scope of protection is not always the same in different countries. Even in Europe, we can find sometimes that the scope of protection, for instance, of copyright is not exactly the same. Of course, that creates issues when we're having cross-border e-commerce. And then there's the scale of e-commerce. I think just in my own country, which is very, very small country, Denmark, with 5 million inhabitants, which in China absolutely sounds like nothing. We receive every week more than 300,000 postal packages from outside of the EU, just arriving in Denmark through e-commerce. So it's just, and these numbers are growing, they're like exploding. And I think the predictions will be that in 10 years time, the number of postal packages will be 10 times the amount that they are today. So there's an enormity of transactions and an enormity of number of postal packages and express courier packages. And then of course, already as Conan hinted at, anonymity features on the internet and inadequate and incorrect account information is a challenge, of course. And then we see new technologies being applied. Conan talked about how Amazon successfully applies artificial intelligence in the fight against counterfeiting, but artificial intelligence is increasingly being used as a tool to commit counterfeiting offenses, because artificial intelligence is becoming cheaper and cheaper to use, and it doesn't really take much technical knowledge to use artificial intelligence anymore. So that can be used as a tool to scale up illicit commerce and to prevent the disruption of enforcement action, something we have to take into consideration as well. Now, we have faced a number of challenges for our intellectual property rights legislation in Europe in regards to e-commerce, and these are some of the decisions that the Court of Justice of the European Union has made in this regard. And I will mention just one of them to just illustrate how it has been necessary for the judiciary to adapt to e-commerce so we could remain effective. And I'll take the first decision here, that was what we call the Blomqvist case. The Blomqvist case was basically, we had a person that was sitting in a European Union member state, and he went on an e-commerce platform that was located outside of the EU. And he had a look at this web page, and then he found a product he wanted to buy. He found a $200 Rolex watch, which evidently was a counterfeit, because if you of course know that the price of a genuine Rolex would be hundreds of times higher than that. And he was fully aware that he was purchasing a counterfeit Rolex, and he wanted a counterfeit Rolex. So he orders the good, he pays for it, and the ownership of the watch goes to Mr. Blomqvist at the time when the watch is individualized and put into the postal package. Now, the vendor is sending the Rolex watch to Mr. Blomqvist. Now, trademark law in the European Union, as most places, only protects acts in the course of trade. And Mr. Blomqvist is certainly not acting in the course of trade, because he is just a normal customer. So when the customs office intercepts the package, there is kind of like a problem here, because customs can only interfere if there is a violation of substantive intellectual property rights law. In this case, trademark law, actually also copyright law, but let's just focus on the trademark law. So customs intercepts the package and say, this is a counterfeit. And Mr. Blomqvist says, no, you have to deliver it to me, because I'm not acting in the course of trade. I'm just a normal customer. When it goes to the first instance court in the EU member state, the first instance court says, yeah, but we will make an illusion like the watch was produced in the European Union. That has no founding in trademark law at all. It's appealed to the Supreme Court of the country in question, and the Supreme Court asks guidance from the Court of Justice of the European Union. And the Court of Justice of the European Union makes a genius addition to trademark law, because they say, yes, it's true, Mr. Blomqvist did not act in the course of trade, but the vendor placed outside of Europe is still acting in the course of trade, because the marketing, sale, and delivery of a counterfeit good is a line of interconnected actions that leads right up to the arrival of the package on the doorstep of Mr. Blomqvist. Now, that would have been hard to read out of the trademark law itself, but this is just one example how the Court of Justice of the European Union have been able to develop the concept in different intellectual property laws to adapt to e-commerce. If this decision had not been made by the Court of Justice of the European Union, the effectiveness of trademark protection would have been undermined in regard to cross-border e-commerce. Now, data protection has been an issue of raising concern, especially in 2016, we got a new general data protection regulation that also applies to e-commerce. That regulation is based on something we call fundamental rights in the European Union. We have the right to respect for private and family life in the European Convention on Human Rights, and we have the right to protection of personal data in the EU Charter of Fundamental Rights. We have several other directives and sets of rules around data protection, some targeting law enforcement, some targeting electronic communication. but the general data protection regulation applies to e-commerce. It was passed in 2016 and came into effect in 2018. And the idea was that the interim period, the companies would then change the setup and their way of processing data to comply with the rules. And one thing that the data protection regulation did was that it applies to data processing carried out not only in the EU, but actually also outside of the EU, if it concerns goods or services that are offered to citizens in the EU or the behavior of EU citizens are monitored. One of the principles that applies in the data protection regulation is that the setup of data protection has to be done with privacy as part of the technical design and privacy as default. The main principle in the legislation is that personal data must be processed in a lawful way, a fair, transparent, proportional, and accurate way that is limited to purpose or subject to freely given, retractable, informed consent. It must not happen longer than necessary, and it shall maintain integrity and confidentiality. There has been several cases already around e-commerce. Just the last week, a new case came up with a website that was selling tickets, travel tickets, and they kept all the customer information for a period of 5 years, even if the customers had stopped their account with this service. And there was an action by the data protection authorities against this violation of the data protection rules. Now, the data protection changes have, of course, the effect that when less data is retained at the different operators of e-commerce platforms, there will be less evidence available for law enforcement to get access to. And already now we have seen that in certain areas on the internet, there is less easily available evidence after the data protection. We also have extended protection for certain sensitive data like health data, political, religious affiliation, and trade union membership, maybe not so relevant for e-commerce. Another set of rules that has a great impact on e-commerce are the cookie rules. You know, a cookie, that small piece of program that can detect the actions of the user of a device, and that can help the means of communication between an e-commerce platform and the user. Now, the principles is that unless a cookie is strictly necessary for the transaction, consent has to be given by the user. I'll give you some example. Shopping carts, for instance. Well, it's necessary to have a cookie to set up the shopping baskets in many situations. But if the cookie is persistent and the user logs out and logs in at a later stage, then consent has to be given to such a cookie. And authentication is very often necessary to keep the connection running while people are on the website. So that is a necessary cookie. But if it's persistent, consent has to be given. For security reasons, the same applies again. For instance, cookies for security of non-requested services will require consent. Network management, you know, cookies that will make sure that the traffic on the website functions and is not overloaded are necessary. But if it's just for analytical purposes, consent has to be given. And again, there can be cookies for default user preferences. Sometimes they are necessary. But if it's for social media plugins and tracking cookies, consent has to be given. And all kinds of advertising technologies, ad tech cookies, has to be given consent. Now, these rules also apply to tracking technologies that are based on non-cookie based technologies. So even if a cookie is not placed, but a tracking is initiated about the behavior of the customer, these rules also apply. They're very, very relevant in regards to e-commerce as well. We have specific rules about data transfer. I think it will go a little too far in this presentation to start talking about those, but they're very, very relevant. And the ability to transfer data from the EU to other countries are quite restricted, and there's quite a number of rules that has to be complied with in that regard. Now, I mentioned the challenges of e-commerce, and now I mentioned the impact of the data protection rules. So how do law enforcement collect evidence in regards to e-commerce? Well, we have certainly certain challenges about it. Of course, what law enforcement is aiming always is to disclose the identity of the infringers. As we mentioned before, the enormity of the number of transactions and the enormity of data, of course, makes a challenge, because looking for the right piece of evidence will be hard. And we have the jurisdictional limitations. I'll come back to that. And then, of course, the technical capability of the investigators. It's really, really important today that the law enforcement agencies have specialized investigators that are able to detect open source intelligence, do the right IT forensic investigations, and are fully knowledgeable about all the places where electronic evidence is placed. We are seeing more and more very highly specialized investigators, very often without police background, with a more technical background. It's really important. And then, of course, the way the criminals are operating in the online environment is much more free than in the physical world, where you are constrained by physical reality. But online, you can be placed almost anywhere in the world and you can still operate. And then we see new criminal modus operandi and the use of new technologies. One of the examples is artificial intelligence, but of course also cryptocurrencies and very advanced anonymization techniques. And of course, anti-forensic and anti-enforcement strategies and techniques are being applied as well. I like this quote from 16 years ago, and I think it still holds true. Cybercrime differs in several fundamental aspects from real-world crime. The type of crime which our existing model of law enforcement was developed to address. As a result, the traditional model is not effective means of dealing with cybercrime, and this certainly applies as well to the crime in regards to e-commerce. I think this is even 16 years later very, very true. Our law enforcement systems was created for the physical world, and we are slowly adapting. And we're getting better and better at it, but we are slowly adapting to it. So we are looking for e-evidence in regards to illicit e-commerce, account information, who was behind an account, information about the communications, browsing history, content of the communication, the marketing and trading activity and history of the infringers, and financial and payment information. And I will, as the last point here, go through 4 different types of evidence that law enforcement can be looking for when determining illicit trade on e-commerce platforms. Of course, we have open source intelligence. Normally, that's very easy for law enforcement to use. There are very few constraints. The evidence is obtained immediately, but of course, the scope of the evidence is limited because it's only what will be freely available on the internet, and the quality of such evidence can be of variable quality. Then there can be voluntary cooperation measures set in place between law enforcement and the e-commerce platforms. Conan already mentioned when they are cooperating with some right holders to make criminal complaints. That would be an example where information would be disclosed in a voluntary way, but there are many others as well. There are normally very few requirements to access such information for law enforcement. It will take some time, but it's still quite fast procedure. But of course, sometimes the scope of the evidence will be limited. But on the other hand, the quality will usually be quite high. Sometimes law enforcement will be able to access the information on the account directly through login credentials that are either voluntarily or non-voluntarily obtained from the defendant. Very often special procedures has to be applied, maybe court orders or other things like that. But the evidence will be immediately available, rather extensive and of high quality. And the last one, the one we only use when it's absolutely necessary, will be international judicial cooperation, because it is very procedure heavy. It's quite slow. Some procedures are going away. For instance, now inside the European Union, we can do it quite without few procedural requirements. And going to the US is even getting easier. But for most countries, there will be a quite complicated procedure that is quite slow. Sometimes it can even take up to 12 to 24 months to obtain electronic evidence from a country outside of Europe and the US. So it can be quite slow. But on the other hand, you can get almost absolutely complete set of evidence in regards to the specific e-commerce platform, and the quality of the evidence is very high. So this just 4 ways of obtaining evidence, and it's used, of course, on a daily basis by the law enforcement authorities and the judiciary of the European Union. We have created a new platform for law enforcement and the judiciary by the European Union Agency for Judicial Cooperation and the European Judicial Network called SIRIUS, with guidelines about how to obtain evidence from each and every different type of intermediary on the internet, including a number of the e-commerce platforms. Takeaway points, just my conclusion, and I will stop here. I think my 15 minutes is over. E-commerce, international e-commerce, poses new and difficult challenges to protection and enforcement of IPR. But the Court of Justice of the European Union has quite effectively adapted the legal framework for IP to remain functionable for protection and enforcement in regards to e-commerce. But data protection is very important in the European Union. It's a very important fundamental right that has implications on almost all aspects of e-commerce, including data processing of vendor and customer personal data and the use of cookies. And crime carried out through e-commerce is difficult to investigate, but the use of open source intelligence, voluntary collaboration, direct access, international judicial cooperation, and the SIRIUS project provides tools that can be used effectively. I know each of the subjects here could have been a 1 hour or even longer presentation, but I am very happy that I was given this short chance to speak, and I will stop now and give the floor to my colleague Antoine. Thank you very much.
Good morning. Just to introduce myself, my name is Antoine Aubert. I'm a colleague of Erling, as he mentioned, working for the EU IPO Observatory. And my work is mainly about cooperation with intermediaries. So when we talk about fighting against counterfeit and piracy in general, but even more in the online environment, it's obvious that cooperation between IP owner on the one hand and intermediary is one of the key part of the is one of the central element of the solution. So I think there was mention of the MOU of the European Commission, so the Memorandum of Understanding of the European Commission, and that is trying to get e-commerce marketplace and IP owner to work together in undermining the use of e-commerce marketplace for the sales of online counterfeiting. And today I'm going to talk about the work we're also doing on trying to find solution and trying to find ways to improve the cooperation with intermediaries. If we can move to the next slide. So just to give you an overview of the work we are doing, and then I will be doing a deep dive in what is the most relevant for this meeting and the work we're doing in e-commerce. But to see how we could actually support better cooperation between IP owner and all different kind of intermediaries. Back last year, actually, we've been creating an expert group that is focusing on precisely this issue, the cooperation with intermediary. And this expert group is made of 30 plus experts with very different background. Some of them working for payment, some of them working for search engines, some of them working for e-commerce marketplace. Then obviously lots of experts working also for IP owners. And the idea of this expert group is very much to look into the kind of challenge that the misuse of different intermediary services is raising when it comes to IP infringing activity. the trends we are seeing in this field, but also, and I would say first and foremost, the good practices that exist to actually undermine the use of different intermediary services for IP infringing activities. And so the purpose of this expert group is really to identify a problem, identify good practices to address this problem, and potentially emulate these good practices and lead to a broader dialogue on how these good practices could be further extended. So as I said, we've been working on e-commerce, and I'll come back to that, but we're also working on domain names. We will soon release a paper on the issue where we've been looking at all the good practices from registrar and registry to prevent the use of a domain name for IP infringing activities. We initiated some work on payment, so to try and find out about all the good practices that are developed by payment service provider to undermine the service, the use of their service for IP infringing activity, and similar work on social media. So we are pretty advanced on e-commerce. We're fairly advanced on domain name. We have some further work to, and we will do some further work in the coming months on payment and social media. One thing I wanted to mention here, and I think that was mentioned earlier, use of technology to also undermine the IP infringing activity, and how different technology can actually be rolled out by intermediaries to prevent the use of their services for IP infringing activity. So we've also been working on automated content recognition technology, and 2 weeks ago we published a report on the issue. And so starting to look into technology that can help or support the identification of video that can be infringing IP. When it comes to e-commerce, we see some companies that are developing some automated content recognition technology to recognize the logo of trademark on IP on e-commerce listing, and potentially be able to see if this product is a counterfeit or not. So we're pretty much working on all these different issues, and now I'm going to deep dive on the work we've been doing on e-commerce with the group, and how it led to a strategic project we're currently working on. If we can move to the next slide, please. So project on enhancing IP protection on e-commerce marketplace. So we initiated the discussion with the expert group on existing collaboration between e-commerce marketplace and IP owner. And obviously our starting point was the upward trends in e-commerce that was mentioned by Erling. With the COVID crisis, we're seeing like an explosion in e-commerce. The growing focus of IP owner on online protection strategy. So as commerce is moving online, so is the focus of IP owner to actually protect their rights in online. But also, and that was part of our starting point, the development by major e-commerce marketplace of IP protection system that were mentioned by the previous speaker, that are obviously one way IP owner can collaborate with e-commerce marketplace. It is obvious that there are lots of e-commerce marketplace, a growing number of e-commerce marketplace, a growing number of notification process. It can be a pretty complex landscape to navigate for IP owner. This notification process can be structured in a different way with different information requirements. So that's another challenge when it comes for IP owner, is to become familiar with these different notification process. In the context of this notification process, IP owner can be asked to provide quite a lot of information about their rights and prove their rights, so verify their rights. So we've been looking into some of this notification process where IP owner are asked to provide scan of their IP title, sometimes ask about further information about the class where their trademark has been registered, or the expiration date. And so notification process can be very simple and straightforward, with some e-commerce marketplace only asking about the registration number of the IP right, but some other platform can ask lots of information. So, and each time an IP owner is actually notifying an IP infringement on the marketplace, he has to enter this information over and over again. We've also looked into the IP protection program of different e-commerce marketplace. And so the one that was mentioned by Conan, the Amazon brand registry, the Alibaba IP protection program, but there are some other from Facebook, from WeChat, with obviously some tools that are made available to IP owner that facilitate the notification. So the IP owner register into the system. He doesn't have to enter the information over and over again. He has access to tools to actually search the IP listing of an e-commerce marketplace, and potentially is able to much easily identify IP infringing listing. There's also some notification mechanism to the IP owner when the e-commerce marketplace has some doubt about some listing and whether they're infringing IP or not. So, and we've seen as well some e-commerce marketplace that are now offering the possibility for IP owner to actually provide information about their good and products to facilitate the automated distinction of IP infringing listing. That being said, it can be pretty complex, and it can take quite some time for IP owner to register into this IP protection program. And one of the friction area we identify is the authentication of IP owner. So when an IP owner wants to join an IP protection program, he has to authenticate himself or herself with the e-commerce marketplace. Sometimes the e-commerce marketplace is sending a verification code. Lots of information about rights can be required, and again, this can take times, and this can undermine the quick and fast collaboration between IP owner and e-commerce marketplace. So if we can move to the next slide. So that's pretty much the, and sorry, if you can just, I didn't know that the box were not showing up, but you can show the different box directly. So I think when we talk about collaboration between IP owner and e-commerce marketplace, right now, the state of play and the situation is pretty much the following. There's an increasing number of marketplaces with different notification system. Some of them have also IP protection mechanism. It can be pretty resource intensive for IP owner to verify their rights whenever they're notifying an IP infringement. It can be pretty complicated to authenticate themselves with marketplace whenever they want to join the IP protection program of an e-commerce marketplace. There can also be duplication of effort to provide information on IP infringing product to different marketplaces. So as IP owner wants to feed information to the marketplace on IP infringing product, they will have to re-enter this information over and over again in the different system of different marketplace. So that's from the point of view of the IP owner. From the point of view of the e-commerce marketplace, so they do have in place some notification process and IP protection program. And I think Amazon talked about how many brands they have registered into their IP protection program, over 350K. But still, they are reaching a relatively limited number of IP rights holder, and many e-commerce marketplaces have much more limited number. And e-commerce marketplace also have to verify the rights whenever they're getting a notification, and this can be a pretty resource intensive process for them. So that's for big e-commerce marketplace, but there's also a challenge for smaller e-commerce marketplace that have limited resources to put in place notification program and IP protection mechanism, and limited access to information on IP infringing product. So with this in mind, we've worked, and we are currently working on a strategic project to develop tools and concrete services to improve the situation. And that's what I will briefly talk about in the next slide. So as EU IPO and to try and support better collaboration with between IP owner and e-commerce marketplace and e-commerce marketplace from all around the world, we're working on an initiative that has 3 different legs and 3 different parts. We are working on developing information resources on marketplace IP protection mechanism. So the notification process, the IP protection program. As I said, for IP owner to navigate the growing landscape of notification system and IP protection program can be pretty complicated. So what we will be working on and information resources that we will make available starting next year is basic information about the notification process of different marketplace and their IP protection program with link allowing IP owner to get access to this IP protection mechanism. We're also working on a search tool that will facilitate the verification of rights. So the idea is pretty much to provide e-commerce marketplace with tools that will allow them to very easily verify the rights. So instead of having to ask all different kind of information to IP owner about their rights, if they just have the reference of the IP rights, they can just they can simply make a search, find all the relevant information, and the IP owner do not need to enter this information over and over again. We're also working on a system to authenticate IP rights holder, so effectively creating a secure channel for all different kind of IP owner and all different kind of marketplace to actually communicate and exchange information in a secure way. And the last aspect and the last part of the project we're working on is how can we then use this secure system to facilitate the sharing of information about IP infringing goods between e-commerce marketplace and IP owner. So that's pretty much the project we're working on. If there are any question or if anybody is interested in finding out more about what we're doing in that field, I'm very happy for my contact information to be passed by. But that's the project we will be developing starting very beginning of next year. Many thanks.
Thank you very much, Antoine and Erling. It was very interesting indeed to have your viewpoint on matters that we have brushed this past couple of days through more private perspective, through the e-commerce platforms perspective and some business owners or lawyers. So that was very interesting. And on the side of Erling, well, that's very timely because in China we have the draft law on personal information protection coming in for comments. So I'm pretty sure people were extremely interested on data protection in the EU and how it does apply and how it interacts with IP and the protection of IP in e-commerce platforms. Unfortunately, as you can tell for how fast I'm speaking, there's no more times for questions. However, we will have most of the PPTs presented yesterday and today on our website, on the IPK website. And as Antoine said, we can facilitate some contacts if you have specific questions to some of the speakers. And if they agree, we can put you in contact with them to further discuss those matters. So please go also to our survey to let us know your point of view on this presentation, so we can do so we can get better at the further webinars and hopefully organize new activities with CAASA. And so for closing remarks, we will have both the president of CAASA, Mr. Hong Yunfeng, and also the trade officer from the EU delegation of the European Union to China, Ms. Helene Juramy, who will provide us their closing remarks. So.
Thank you, Andrea, and hello, everyone. I want to first thank you for all the good work in organizing this event. And thank you to all the speakers who made themselves available, the participants, and of course to CAASA for being a partner in this important topic for IP rights from the viewpoint of European companies. Of course, we are doing this activity in COVID times, so we have to adapt, and we are here online. COVID times also mean that online platforms are even more important. We saw the increase. And as was mentioned by some of the participants, we really do not want to see a drop in the momentum on the enforcement during these COVID times. It's all the more important now. I was very grateful yesterday when Reinhard mentioned that the issue remains very big for Europe. He mentioned that around 80% of the goods arriving that are counterfeiting arrive from China. So we take this very seriously, and we appreciate to have this discussion now on the topic. Erling also mentioned the postal packages, and this is definitely something we have to keep an eye on in the future and work together on. Of course, the question is also the sales by European company in China. So not only what arrives in Europe, we are also very concerned about the sales here. And on this, I was very thankful for Rieko, who mentioned that there are also health concerns. This is not just a question of intellectual property. We take this very seriously also because of question of safety. So in this spirit, I really hope we can keep the momentum going and continue improving. As some of you know that I've met, I just started here in the position, and I look forward to working with you in all the next years to come to continue improving the situation. Thank you very much.
Thank you very much, Helene. And now I will leave the floor to Mr. Hong.
Dear participants, counselors, ladies and gentlemen, good morning. First of all, on behalf of CAASA, I would like to congratulate on 2020 China-EU Conference on IPR Protection, Online and Innovation for the successful completion of this event. I want to particularly thank the organizer for hosting this event. Despite COVID-19, the two sides are continuing the exchange and collaboration on IPR. We have held this IPR event for 4 years in a row. This year, we are more focused, and we are into more depth as well. We have more topics covered this time. For these 2 afternoons, this is almost like 2 years since China's e-commerce law. The two sides and different participants have talked about IPR protection for e-commerce. Alibaba has talked about their protection mechanism, and JD has their stakeholder collaboration on IPR protection. And Pinduoduo has their way of IPR protection, and Amazon has the way to detect counterfeiting. And EU researchers have also talked about the recent results of counterfeiting for e-commerce, and has talked about anti-counterfeiting related MOUs as something that we can look at for collaboration on anti-counterfeiting. So we've talked about the different categories of the industries and their challenges, and some of the practical measures that we can implement to protect against infringement. And EU IPO has also shared some of their experience and learnings in IPR. So this has really provided to us different perspectives to look at IPR protection. This time we have industry, government, academic, and research institutions all participating in this event. So it's practical and effective. I myself and CAASA whole team have benefited from this event. So we believe that it is the right thing to do to exchange and collaborate on IPR protection. I'm very fortunate to once again to have this opportunity to say a few words here. I want to say to Mick, Andrea, and everyone from EU IPO, and all of the experts from different companies and entities for your participation in this event. We'll continue to work with all of you to roll out more programs to work on IPR protection. December, we will have an online event first, and then followed by another offline event all about IPR protection. So we want to invite you to those events, and we look forward to meeting you again. Again, we want to thank EU members, representatives for joining this event. And we really look forward to seeing you in the December event. I hope that COVID-19 will be over soon so that we can meet all of you offline. Again, I wish you health for the coming months and weeks and years. So thank you very much.
Thank you. Goodbye.
Thank you.
Bye-bye. Take care.